Welcome to Sovereign Citizen Legal Encounters. All right, today we have a sovereign citizen who wants to represent himself in a child support arrearage case. Now, I don't know what kind of argument you want to bring on something like that. And if it's your child, I don't see why you don't want to pay it. But anyway, let's go in, check it out, and see what's going on. And before we go into the video, I want to thank Law Nerds Unite for sending the video to me. His link will be in the description. Check his channel while we got some good content over there. Let's go.
We are ready to start recording. We are live on the record in cause number 23-09-13702. This is a motion to confirm support arrearage. This was filed by the Attorney General's Office November 27th of 2024. The parties are all present before the court today on Zoom. This is a remote proceeding, and I am sitting outside of Montgomery County, Texas, pursuant to the Texas Family Code Section 201.1045. And I find nobody has objected to proceeding this way.
Objection, Judge.
Okay, one moment, sir. Ms. Baskins, can you please state your full name for the record?
Yes, ma'am. It's Adrienne Baskins.
Okay. And sir, can you state your full name for the record, please?
Yeah, I'm Zahir Dean, the living man.
I didn't know living man was a title.
And Mr. Dean and Ms. Baskins, can you both please raise your right hands to be sworn in? Do you each solemnly swear that any testimony that you'll give today will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay. Is everyone ready to proceed today?
Yes, Judge Julie Kahn for the Office of the Attorney General.
Before we begin, a few
I'm
housekeeping items. The first is I am an associate judge, and you do have the right to a de novo hearing before the referring court regarding decisions I make. Also, we generally take testimony in court. It's important one person speak at a time. We should use civil tones with one another. Once we start taking testimony, one of you will be asked questions at a time by the Assistant Attorney General. If you're not the person being asked questions, if you have a legal objection, please interrupt, but otherwise, please don't interrupt them or answer for them. You'll both be given a chance to be asked questions, and at the end, you'll both be given a chance to speak as well, since you don't have counsel representing you. And then lastly, just know I'm not with the Attorney General's office, and so things you've discussed with them in the back or spoken to them about, they're not allowed to tell me about that, and they don't. So you're likely to be asked questions that you've answered already today or other days. All I know about your case is the pleading on file, and then I believe you were before me once before. So I vaguely remember that, but do keep in mind I have multiple hearings practically every day. And so not all details stick in my head from day to day. That being said, Mr. Dean, you wanted to say something?
Yes, thank you, Judge. Judge, I'd like to say I'm here on special appearance. But first, we were here last time, and I was really sick and I wasn't able to speak. So I appreciate you giving me the time to recover and come back here today.
Better.
So I'm here on special appearance, Judge, and I am looking for a dismissal of this case due to due process violations. I was not given proper notice. And in the notice, I wasn't given a clear statement of the proposed actions. I wasn't given the specific reasons or grounds for the proposed actions, including a description of the facts and evidence upon which the actions based off of today. I wasn't given sufficient detail so I can understand what is at stake and what I need to contest or respond to. And I wasn't given information about how to access the procedures for responding or contesting the actions, including contact details.
Well, you can tell he's reading a script, and it's amazing how he wants to go through all of this for a case of arrearage. Let's keep going.
So because of this, I'm requesting a dismissal of the case, Your Honor.
And just for clarification, sir, have you filed anything requesting this relief?
No, because I don't know what's going on.
Okay.
I don't have any information.
Ms. Khan?
Was not noticed given the proper notice. And because of that, there's no way for me to proceed.
Yeah, I offered to email them to him this morning. He was served back on June 10th, by side posting. And
So
on
he's
his door, he
Objection,
was served.
objection, is there evidence to prove that, Your Honor?
So I'm looking for the service return right now.
I have it pulled up. I can share the screen if I need to.
Okay. You might as well, so he can see it. I have it pulled up as well right now, though. It's a different device.
All right, they're going to post a document on the screen, but it's going to be blurred out because all their personal information, such as addresses and things like that, are on there. But you'll still see them on camera in the top right corner. And also in reference to him being served, if the court verified that you already live at a certain address, they can send someone out, post the hearing on the door, and walk away. They don't have to actually hand it to you in your hand. So he's using that to say, well, there's no proof that anybody gave it to him or posted it on the door. So that's the angle he's using to delay the case.
So it says on June 10th, 2025, it was posting the citation to the front main entry door per Texas Rule 106.
And I do take judicial notice of that executed service return.
Oops. Okay, so that was just the preset, but this is also the motion to confirm and the motion for substituted service was all served on him.
Oh yeah, it's multiple. Yeah, the 3 pages in that service return.
If I've got an objection on that, Your Honor, it says it's posted on my front door.
At the front main entry door is what it says.
Yeah.
Yes.
I did not receive that, Your Honor.
Do you think it's possible he didn't get it? Let me know in the comments.
I've got an objection to that.
And hold on one moment.
I believe he also signed the reset last time we were here.
Yes, I do believe you've made an appearance in the case. So sir, you're claiming right now that you don't have a copy of the pleading. Is that true?
So I've got an objection to that as well, Judge. So when we were here before, I did have a means to communicate with the clerk prior. However, during the Zoom when we were speaking to you, I did not have a means to communicate in terms of chat for me to object to that. But now I'm able to speak. I agree on a reset to come back to figure out what's going on here, but my objection still is for due process not having the sufficient amount of information.
Judge,
Not-
I can I apologize.
That's okay. Please talk.
I'm willing to take a short reset. I can email him the pleadings. I've offered to do that before, and if he needs a chance to look them over.
Yeah, and I've got an objection to that, Your Honor. Due to the due process violation, I'm requesting a dismissal.
Okay, sir, this is not a well, I'm finding it's not a due process violation. You are here, people are allowed to make appearances before the court. You've made an appearance before the court multiple times now. I'm not dismissing this lawsuit. It's a matter of making sure you do have proper notice to proceed, though, and fairness. And so I do want you to receive a copy of the pleading so we can proceed. I do believe last time, Ms. Khan, because I thought this case involved a modification and confirmation. I believe last time Ms. Khan, correct me if I'm wrong, I think it was this case, corrected me and said this was just a confirmation of arrears. We're just confirming arrears in this case.
That is correct, Judge.
Doesn't make it any less important. There may be all sorts, there might be, I don't know, there could be possession credit issues, there could be direct payment issues, could be all sorts of things. And I want you to have your day in court in fairness. But I am denying the request to dismiss this action. I don't find it's been a due process violation. Have you provided Ms. Khan information, a way to send you a copy of the pleading so you can review it?
Your Honor, so I've got an objection on the appearance as well. I'm not here, or nor have I ever been here on general appearance. I've always represented myself under special appearance.
So he showed up for court the last time, but he's saying he really didn't show up. So if that's the case, maybe they should issue a bench warrant, and maybe that'll get things straightened out.
I don't know what that means, sir. Are you not a person?
I am the living man.
What does that mean?
I am a man.
Eh?
You are a man, I'm a woman, but I'm here. You're here.
I'm here as a living man representing myself.
Under what legal basis are you doing that?
Under constitutional law.
I'm sure he wasn't expecting that question.
I'm finding you're here and you're making an appearance, sir. I don't know what law you're referring to. If you'd like to cite a specific statute or a specific part of the Constitution, I am open to reading it. But my understanding of the law is you're here, and there's no legal representation of yourself in that form. So I would like you to receive a copy of the pleading. I'd like you to review it. If you need additional time, I'm even open to resetting this to the December 11th date, although I'd rather not. But in fairness to you, if that needs to happen, I will give you a little more time.
That would need to happen, Your Honor.
Okay, but I want you to receive a copy of this pleading so we don't have the same discussion next time.
I've
does-
sent it. Can you check your email and make sure you
Oh.
have received it?
I'm checking now.
Okay, thank you.
I received it. I don't know if you heard me, but I'm sorry. I said I received it.
Okay, thank you. So you did receive it,
I
just to
did.
confirm.
I did via email.
Okay, do you want to review it now or do you want some time to review it before we proceed?
I'm sure you know which option he's going to take.
It's a pretty long document. Yes, very long document. I'll definitely need time to review.
Okay, and just so you know, despite the length of the document, we will be proceeding to final trial on December 11th, 2025. No more resets. I expect everyone to be prepared. I think I told you all this last time, but be ready to proceed next time with I did say this last time, with any witnesses or any documents in electronic form. Be ready to go.
Yes, ma'am.
Okay, so it is reset for December 11th, 2025 at 9 a.m. on Zoom, the same Zoom code information.
All right, I will send out a reset. Just give me about 5-10 minutes and I'll send it to your same email.
Okay.
If you want to go back to the breakout rooms and make sure I get the resets to you.
I'm okay with the verbal reset. I'm not going to sign any documentation.
Okay, I'm just letting you know, I'm going to put in Odyssey that you have been noticed of today's setting, and if you do not appear next time, we'll proceed with or without you, sir.
That's fine, Judge.
All right, well, I guess Ms. Baskins, you're free to go. I will send you the reset. Just check your email in about 5-10 minutes for me if you can.
Thank you.
All right, we'll see how things go when he comes back. Now, you let me know in the comments if you think he's going to come back. Now, for me, I think he's going to come back, but he may come back with a twist of something else going on while they can't proceed. But let me know what you think. Now, we're going to go into a second hearing that I didn't mention in the beginning. We're going into Judge Wolf's court, where we have a pro se defendant who's trying to represent himself. And also, he had a no contact order that he violated, but he has all these explanations behind it. So this is just something for you to listen to and check out. So let's go in. Let's go.
All right, I'm going to take up the matter of Butler versus Butler. All right, Mr. Butler has filed a motion to alter or amend the judgment in this case. And Mr. Butler, this is your motion, so I'll be glad to hear you.
Yes, sir.
Come to the podium.
Yes, sir. It's hard to remember. I'm currently incarcerated right now and trying to remember everything since I've had no time to really prepare
We might get a sense of what's going to happen in this hearing already.
since this. I've also filed a motion for mistrial, and is that part of this too? Or-
I have a motion to alter or amend, and I then have
Sorry.
so I'm giving you an opportunity to address all of the issues that you have raised in your motion to alter or amend. Do you not have a copy of it?
I'm not with me, no, sir, because I'm incarcerated right now due to being targeted.
Let me tell you what you said in your motion. Says that you're filing this motion pro se pursuant to rules of civil procedure 59.04 to alter or amend the final judgment in the following basis. You allege the final hearing was held in the matter on July 14th, 2025 and July 15th, 2025. The court's judgment is based on erroneous findings of fact and a fundamental failure of due process, which constitutes a manifest injustice. And do you want to address that issue and what it is that you're saying occurred
Yeah, the illegal ex parte meeting that happened during the trial that happened. And then also, I think it was $800 a month I was supposed to pay in child support. And that was based on her income. And I do remember you specifically saying that the child support should not be based on her income due to me. Like I was laid off from my job, and I wasn't looking for a job because I am, and I've never made as much money as she has.
Well, I want to address that second statement you made. Paragraph 3 of your motion states, the court engaged in improper ex parte communication. During respondent's cross-examination of the petitioner on July 14, 2025, the presiding judge, the petitioner, and the petitioner's attorney exited the courtroom and held a private meeting in the judge's chambers. The respondent was excluded from this meeting, which violated his fundamental right to due process in the Tennessee Code of Judicial Conduct, Rule 2.9.
Yes, sir, that did happen.
You're alleging that I had a communication with the attorney for the petitioner and the petitioner and about your case?
I'm not exactly sure what happened. I just know that.
Well, you've made an allegation, which I consider to be a very serious allegation.
Sure.
And when I'm talking, just wait for me to finish. So I want to know what proof you have that such a meeting took place, because I can tell you it did not. But I want to hear what evidence you have that you would have placed in such a motion.
So the only evidence I have is that when we were here, and I was actually questioning Mrs. Butler, that all of a sudden Miss Margaret got up and then she got up, and I noticed that you three went through that door, and then I was just left standing here. I didn't know what to do, so I went back and I sat where that man in the blue shirt is right there. I went back and sat right there for about 10 minutes. Miss Butler exited that door. And then about 5 minutes after Miss Butler came out, Miss Margaret came out, and then you came out. I don't know what you guys said. I just know that.
So you have
happened.
no evidence that any such so-called meeting occurred between me and Miss Brady and the petitioner in this case. You're just assuming that such a meeting occurred because we left the courtroom at the same time. Is that correct?
I just don't know what else would have happened. I did file for a mistrial first, and I don't know why that didn't come through. But I do know that I wasn't getting dates while I was filing stuff. So I tried to, did the mistrial first to make things. I don't know if it would make it right better or.
Well, if he had an attorney, he would know exactly how it goes.
I'm just trying to do the best I can, Your Honor. I lost my son. I was doing everything right. Like, the courts asked me to take a drug test. I passed it. I didn't get my son. I lost my son on false allegations of drug use, and did everything the courts asked me to do. I still didn't get my son back. I lost everything, Your Honor. I lost literally everything. And I've had the Cheatham County Police, they've targeted me, and I've got evidence of that. And it's just, look at me.
Paragraph 4, you allege that the petitioner provided false testimony under oath regarding allegations of domestic violence, which the court relied upon in its ruling. You vehemently deny the allegation that you jammed your thumbs into the petitioner's eyes or punched her. Basically, you're saying that I relied upon false testimony, but I heard both sides of that testimony. Well, I heard her testimony, and I think you were pending criminal charges at the time, correct?
Yes, sir.
Okay. The paragraph 5, the court's judgment relies on a pattern of false allegations. Prior to the final hearing, the petitioner filed an ex parte motion to suspend your parenting time based on claims of drug use and unsafe home. Those claims were investigated by the Department of Children's Services and were proven false. Furthermore, you passed a court-acknowledged 10-panel hair follicle drug test. Anything you want to add to that? I'm considering your motion, so I'm giving you an opportunity to
Yes, sir.
provide me with any kind of proof regarding your allegations.
There was also, there's the allegations that I was homeless, and then they came and inspected my house as well, and did a home visit, and she saw I lived in a beautiful home. I was very stable, and after that, Judge Turnbow, I didn't get to get back in front of him because he went. They go. I guess y'all guys alternate. So I filed another motion, and I was running late to court that day due to my car issue, and I've since filed a motion for that. And but I called as quickly as I could, and the lady said that your case had already been heard and they're not going to do anything.
Let me know how you feel about this guy's story. Now, his car broke down, but he said he called as quickly as he could. Well, that could have been all day. We don't know if his hearing was in the morning or in the afternoon. But if the clerk said, hey, the hearing's been held, there's nothing we could do. I mean, there's other means to get into court. Uber, Lyft, you got a bunch of different options. But who knows what happened with him that day.
I was just devastated. I was just like, because I thought that would be the day I get my son back.
All right. Paragraph 6, the allegation of harassment at the ninja class is further evidence of this pattern. The petitioner obtained an order of protection based on claims of harassment and threats. The incident did not occur. Class was held in a small room filled with numerous parents and children. No independent witnesses came forward to support the petitioner's story because it did not happen. Paragraph 7, the petitioner's attorney made false representations to the court. The respondent inadvertently sent a draft email with no threats to attorney Margaret Brady. Attorney Brady then falsely told individuals in the courtroom that the email contained threats and a deliberate attempt to poison the proceeding. So you have filed a motion making these allegations, and today is your day to show to the court the basis for any of those allegations.
Sure. So for the ninja class, it was worded in such a way that I so happily showed up there. And I feel like the way that things were worded to obtain this no contact order, it was specifically for that and for that only. And just before that incident, or there really was no incident, I was trying to break contact off of Miss Butler because of just how angry she was. And I just wanted to support my son. I've been there since day one supporting my son. And for whatever reason, these people just come out of nowhere and just don't want me in his life. And that's exactly what has happened. And then there was no need for a no contact order. There was no need for that at all. And it was there strategically to violate me 100%. And it was malicious, if you ask me. That's how I feel. I don't have anything with me right now, but and then also my probation was violated at the wrong place at the wrong time, and I'm fighting those charges and more than likely will win. And Miss Brady, before the proceeding of the violation, was telling the courtroom that I have a draft email, and for whatever reason, it was addressed to her, and it was nothing of the sort of threatening.
Draft emails normally don't go out of your outbox until you send them. So I don't know how she saw that.
And Miss Brady was talking about it in the courtroom the day before my violation was set to be heard. And my attorney said, "Where's this threatening email?" And I gave it to him. I said, "Here." And there was nothing in there threatening. So for whatever reason, I felt like she was trying to poison the well before it even got started. Because, her sister-in-law does work down there.
All right. Have a seat at the table. Ms. Brady, do you want to respond to the motion to alter or amend the judgment?
Your Honor, we would just say that,
You'll come to the podium, so
Sure.
let's pick up.
sorry. Obviously,
we would say there's no ex parte communication with the court. But all the other things that he mentioned in his motion are based on witness testimony, and the court had that opportunity to hear that then and deemed Ms. Butler's version of events to be credible and made a ruling based on that. And we would say that there's no grounds for to alter or amend this judgment put forth by Mr. Butler today, and we'd ask that that be dismissed and this be considered a final order.
Number one, the court specifically will address the allegation that the court engaged in an improper ex parte communication. Mr. Butler has affirmed on the record that he has no evidence of such a meeting occurring, other than the fact that circumstantially Ms. Butler and her attorney, Ms. Brady, exited the courtroom, and that I exited the courtroom at the same time. That alleged meeting did not occur. There was no ex parte communication between me and Ms. Brady and Ms. Butler. And I specifically find that that allegation was made without any evidence and nothing more than circumstantial belief by Mr. Butler that somehow something was being done inappropriately. So I find that that basis is a false allegation regarding the behavior of this court and that of Mrs. Brady as the attorney for Ms. Butler. In addition to that, all of the other, as Ms. Brady has pointed out, all of the other allegations that he makes are all basically complaints regarding the court's findings at an evidentiary hearing. And the court finds that the testimony that was offered at that hearing was the basis for the court's order that was entered, the final hearing order. And that final hearing order was filed September the 2nd, 2025, which was after his motion to alter or amend. And that hearing order was based upon the facts as were presented in this court at the final hearing, where Mr. Butler was present and given an opportunity to participate. And that as a result of that, no evidence has been brought forward to satisfy the court that there's any basis for an alteration or amendment to the court's prior order. Therefore, his motion to alter or amend the judgment filed August 25th of 2025 is overruled.
We knew that was coming, but denied sounds so much better.
Then there are some additional motions that have been filed, and I would like to address those motions, and Ms. Brady, unless you need additional time to consider them. He has filed on October the 1st a motion to reconsider and amend the final order as to child support.
Which might not be the top of your list. I filed a motion to dismiss all of the remaining motion and for sanction. And so if we have argument on my motion to dismiss, it might resolve those motions. Might be a way to handle it. Some people won't be able to see.
We'll consider your motion to dismiss, considering and consider that before we take up any of these other motions, because if your motion is valid, then it will not be necessary to consider those additional motions.
Your Honor, so the other motions were not, as you know, set on the docket today, but I wanted to bring them all up before the court today so we could just deal with this all together. So as you can see, I filed a motion to dismiss. He has additionally the motion to reconsider and amend as to child support, an emergency motion to reinstate parenting time, and for immediate hearing, a motion for mistrial. There was a motion for personal items that's already been dismissed by Judge Turnbow because for failure to prosecute. So on these remaining motions, Your Honor, I would say that these are going to fall kind of in the same lump as the motion to alter or amend. They're all based upon problems that Mr. Butler has with testimony that the court considered that he had an opportunity to cross-examine and participate in that hearing. And we would ask that all of those be dismissed. And furthermore, Your Honor, we've also asked for sanctions pursuant to Rule 11.02. And specifically, Ms. Butler is asking that she be reimbursed for her attorney's fees to defend this motion today. as we know, there's been a history of harassment and stalking and domestic assault. And now that Mr. Butler is unable to do that out on the street, he's using this court to continue this harassment because he's dissatisfied with the court's ruling.
Oh, now we're getting a better picture.
And he has had no basis for these motions. And so we would ask that he be responsible for attorney's fees today. Additionally, though this was very late filed, and I'll acknowledge that, I filed a motion to relocate, and also we're having a problem selling the house. I understand if Mr. Butler doesn't want to deal with that today, he has that right. But you had asked that if we can't get the house sold at list price, that we need to come back and talk to you about that. And they've had one showing the whole time that it's been on the market with no movement. And we're asking that if the court will hear that today, that we be allowed to accept the reasonable recommendation of Amanda Bell, who is the realtor, and just try to get this house sold. But I understand if that needs to be reset.
When you say I had asked you to come back and talk to me, you were talking about having come back to court on that issue.
Yes, Your Honor. So in our final hearing, our final decree, you had said if she's not able to sell it at list price, that we needed to get permission from the court to reduce that price so that there was a basis for it. And if you need to hear from Ms. Butler, we can do that to describe
you
that.
just filed it yesterday,
Yes.
so I'm not going to require Mr. Butler to have a hearing on that particular issue because of the fact that he's entitled to 5 days notice prior to that. We can set it later in this month for a hearing, but
Okay.
it would not have to be, it would not be fair to him to have a hearing today with a motion filed yesterday.
I understand.
Mr. Butler, did you raise your hand? Do you have something you wish to say?
Yes, sir. The house is listed way too high. It's listed at like almost
I'm up to
400,000.
the podium.
She has the house listed way too high. It's at 400,000. It's not worth that much. I understand that the market value has fluctuated these last few years, but it was nowhere close to that. And then also with the motion for emergency custody was because I satisfied everything the court needed me to do. But right now I'm incarcerated right now with no probable cause. So, that's why I can't keep up with everything. And a lot of this is not based on, so I don't know. I've lost everything. I lost my son. I've lost literally everything for nothing. And they just want to take more and more and more and more. I can't even afford a lawyer, but I got to pay for her lawyer fee. And then they got the house marked up way too high. And then, Your Honor, I just really hope you'll take into consideration that, a lot of this was done and I have been targeted by the Cheatham County Sheriff's Office. They violated my probation the first time based on words. And then, I've got proof of it. I've got proof of it. And a lot of it came from her. And I just really hope you'll take that into consideration, Your Honor. I mean, I've been a good parent. I'm a supportive parent. I've worked our entire marriage. I've worked until I lost my job. And then on top of that, I didn't just sit there. I went out and I made money. It wasn't, a bum. I did what I could for my son. I went from being that dad every day with my son to nothing. And they just took everything out of my life. I'm in jail right now for nothing because they targeted me.
Well, you certainly can't be arrested for nothing and booked into a jail without any charges. And also, a lot of times I hear when things are not going in the defendant's way, they always want to blame the sheriff's office or police for targeting them for certain things. Because I hear that in a lot of cases that I cover.
Because she could win 100%.
All right. You have also, and Ms. Brady, I'm going to go ahead and consider these other motions on the record because it's my understanding he's filed an appeal. Is that correct? He's filed a notice of appeal to the Court of Civil Appeals, and therefore I think that all of these motions need to be addressed that he has raised regarding the final hearing. So the next motion that I'm going to take up is an emergency motion to reinstate parenting time for immediate hearing. Mr. Butler, you have filed a motion to reinstate your parenting time.
Yes, sir. I did. That was before I was on private property, and the Cheatham County Sheriff's Office came up and arrested me for being on private property, and now I'm here. And so if I were to win this, I guess I couldn't get it anyway because I'm incarcerated. But so yeah, I don't know if maybe when I get out, if you were to give it to me. So. But Miss Butler's whole goal was to move back to East Tennessee, where she was from. That's why this, the no contact order for no reason came into play. And that's why a lot of this is like the whole targeting thing is like so aggressive, is so that way she can move back to East Tennessee. 5 hours away. I mean, no, not that I'm a bad dad, not that, I'm out partying, I'm out doing drugs, nothing. It's just bull. And they've got me hemmed up. I mean, it's hard when you're a small guy. You got no lawyer. Well, I did have a lawyer. She withdrew from my case because of Margaret Brady. I've got her on tape saying that. She doesn't want to go against Margaret Brady. She's took all my money, so I had no money left, so I had to defend myself, and I still lost fucking everything.
Okay, now he's going too far.
I mean, I've lost everything, Your Honor. I'm sorry. I'm not. It's just. I mean, I'm a good dad that's fighting to be with his son, and I just keep getting shot in the foot. It's pretty bad. It's pretty.
Right. Your motion to reinstate parenting time and for immediate hearing is going to be denied simply because of the fact that you're incarcerated. I'm not going to reinstate parenting time because you are incarcerated, but the final order in this case provided that upon your release from jail, that you would have the right to exercise supervised visitation every other Saturday and Sunday from 9 a.m. to 5 p.m. each day with no overnights. That would be supervised by a third party agreed upon by the parties. That you would be permitted to petition the court for review of your parenting time after your criminal charges were resolved without the necessity of showing a material change of circumstances. I don't know how it could be any more fair with you in the situation that you're in. All of your argument has to do with how unfair you think it is that you're incarcerated. That's not an issue before this court. The fact of the matter is you are incarcerated.
You're right.
And because of that fact, you're not going to have visitation with your minor child or children until you are resolved of that. And this final order that I put down provides a method by which you can have visitation, and you can even have it reviewed after all your criminal matters are resolved to try to reinstate some sort of a normal visitation. So your motion to reinstate and your visitation immediately is denied based upon the fact that there is provision in the order for that to take place. The next motion that you have is a motion for a mistrial, and I will just simply, I don't even need to hear any argument. Your motion for a mistrial is based upon paragraph 1, ex parte communication, July 14th, 2025, during the final hearing in this matter, the presiding judge, Judge Wolf, plaintiff Aaron Butler, and plaintiff's counsel Margaret Brady left the courtroom together and entered into the judge's chambers for approximately 20 minutes. Defendant Robert Butler was not invited nor informed of the content of the discussions and was not given an opportunity to respond. The ex parte communication deprived the defendant of due process. I've already addressed that issue with you. You have affirmed on the record that you have no evidence of any such meeting occurring, that it was all circumstantial because I left through this door to my right, they left through the door to my left, and as a result, during a recess of this court, that you assumed that.
And you know what's said about assumptions.
That there was some sort of ex parte communication. I affirm on the record that no such communication took place and no such meeting took place, and that allegation was based upon a false statement by you. Therefore, your motion for a mistrial is denied. All of the rest of this, of your motion for a mistrial, which is not appropriate after the final, you don't file a mistrial motion after the case is concluded. And for that reason, in addition to the fact that I've considered all of the other bases, and there is no basis for a mistrial to be granted after the entry of the final order in this case. The last motion is a motion to reconsider and amend the final order as to child support. And at that point in time, I found that the mother's income was set at $6,000 a month in the final hearing, that your income was imputed even though you were in jail pursuant to the rules of the child support guidelines, simply because of the fact that if you were unemployed, it was due to your own fault. As a result of that, you could have the imputed income that the child support guidelines provide. I applied that to the calculation of child support, and therefore you're not entitled to an amendment as to the calculation of child support. That concludes all of the motions that are set, other than the motion to relocate, which was filed yesterday. I will not consider that until he's been given appropriate notice, an opportunity, and that would be later in the month that we have a chancery day we can set it.
Your Honor, I know that we're not taking up the motion for reducing the price of the home either, but since Mr. Butler seems to be on the same page as that, you think that we could consider that so that we can get that house sold and they can get some funds?
If he's willing to do it, we can. I mean, if he's willing to waive the 5 days notice and have it heard, yes. Mr. Butler, the rules of civil procedure provide that you're entitled to 5 days notice prior to the hearing on a motion that's been filed. They filed their motion to reduce the value of the property and to accept an offer less than the listing price yesterday. So therefore, you have the right to object to that, and I'll have it set later in the month, or you can agree to hear it today, and then we'll put on the proof, let them put on the proof about why they need to accept this offer. Do you understand all that?
I understand it all. I guess it just depends on how much they want to reduce the price. If she wants to me and her work out a deal or something, I might be willing to talk about it for a minute.
Go ahead and have a seat over here, Mr. Butler, and I'm gonna let Miss Brady talk with you, and we'll come back to you.
All right, that's the end of this hearing. He didn't come back, so I don't know what's going to happen with that. But it shows in this case that he needed an attorney, and he had a lot of stories, a lot of stuff that was going on, a lot of rambling and things like that. So who knows what really happened with him. So you can put in the comments what you think about the situation with him and how everything went. You think he was telling the truth at some point or not? I think I know the answer, but the comments are fun and I like to engage in them. So I hope you enjoy both videos, and I'll see you around on the next one.